The Supreme Court has granted financial autonomy to local governments in Nigeria. The Apex Court on Thursday ruled that it is unconstitutional for state governors to hold on to funds allocated for the local government administrations. It maintained that the practice, which has gone on for over 2 decades, was a clear violation of Section 162 of the 1999 Constitution as amended. The 7-man panel gave the landmark judgment, delivered by Justice Emmanuel Ajim, held that no House of Assembly of any state has the power to make laws that could in any manner interfere with monies meant for the local government. The Supreme Court stressed that the law mandated that local government must be governed by democratically elected officials, and it ordered that forthwith, funds meant for the local government must be directly paid to them from the Federation account.
That although Section 162, so 5 and 6 of the Constitution of the Federal Republic of Nigeria makes provision that money due to local government shall be paid through the joint account, but that provision was considered to be a discretionary provision, meaning it can be tinkered with. And in their lordship's judgment, they said that is not mandatory. Or their lordship came to a conclusion that money due to local government shall henceforth be paid directly from the Federation account to the 774 local government and 6 municipal council in Abuja. So that laid the matter to rest today.
Demands of justice require a progressive interpretation of the law. It is the position of this court that the Federation can pay local government allocations to the local government directly or pay them through the state. In this case, since paying them through the state has not worked, justice of this case demands that local government allocations from the Federation account should henceforth be paid directly to the local government. The Supreme Court also barred governors from dissolving democratically elected local government councils, while also declaring unconstitutional the appointment of caretaker committees by governors to run the affairs of the local government, ordering the federal government to withhold allocations to local government governed by unelected officials appointed by the state governor. It held that the 36 states are under obligation to ensure democratic governance at the third tier of government.
As far as I'm concerned, there's no winner, there's no loser. The Nigerian people will enjoy the benefits of good governance. I think this has been in the clamor for a long time. It's not personal. What is important is that the people will hold chairmen now more accountable because the funds are going directly to them. And I think that it is time for us to move this discussion forward.
This judgment followed a suit the federal government filed to secure financial autonomy for the 774 local governments in Nigeria.
The judgment on local government autonomy have just been delivered by the Supreme Court. We will get the certified true copy of the judgment as a body. The body of State Attorneys General of the Federation will study it and then we'll come up with our statement on it.
I commend the Lord Justices of the Supreme Court for the judgment that have restored democracy to our grassroots. Because democracy almost disappeared from our rural communities when our governors appropriated the local government powers, rigged local government elections, mismanaged federal allocation.
Earlier, the court dismissed preliminary objections by the state governors filed to challenge the competence of the suit.